Okay, it is 1:00, and I'm Judge Eisnagel. Welcome to an oral argument session of the 5th District Court of Appeal. I'm joined on the panel today by Judge Harris and Judge McIver. Before we get into the substance of anything, it looks like we might have a technological or a connection problem with one of the attorneys. Counsel, can you hear me?
I can hear you, sir.
Counsel Reagan?
Yes, Your Honor. Yes,
Okay.
Your Honor. Christy Reagan, I can hear you.
Okay, and are you unable to connect with video today, counsel?
Unfortunately, I am at this time. I apologize. I am having technical difficulties and cannot get in via video.
Okay, no need to apologize. That can happen to anybody, and so that's fine. So let me ask you then, what would you like to do? Would you like to move forward with your opposing counsel is on video? Would you like to move forward today with knowing that your opposing counsel is on video and you only have audio, or would you like for us to consider continuing the oral argument?
Your Honor, I would leave that to the discretion of the court. Again, I apologize because of the technical difficulties. So whichever way opposing counsel and the court wishes to go, I can follow in either direction.
Well, just for our clarity, then you don't have any objection to going forward with oral argument today? Is that correct?
No, Your Honor, no objection.
Okay.
No objection.
All right. Well, unless I see an objection from a member of the panel or from opposing counsel, then based on that, we would move. I think we would move forward with oral argument. Okay, and I don't see any other input from the panel or from opposing counsel. Okay, so I would just remind counsel to go ahead and silence your phones or turn them off now. And counsel for appellant, I'm happy to help you watch your rebuttal time. Obviously, it's up to you to make sure, but if I miss it, you're still obligated to know that where the clock is, but I'll try to help you. How much time would you like to have in rebuttal, counsel?
5 minutes, Your Honor.
Very good, very good. And with that then, counsel for appellant, you are recognized for your argument.
Thank you, sir. Judges of this court, I'm Rick Sickton. I represent the appellant, Mr. Ronald Hayward. And the question we have today is whether the acknowledged failure of trial counsel to adequately prepare and investigate for this case impacted my client's decision and ability to plea. She lost her main witness a month and a half before the trial was to begin, and that witness established their self-defense case. She waited until jury selection was over with.
You would agree that loss of that witness was wholly unanticipated, right? It's not foreseeable.
Not foreseeable, but preventable based on the numerous continuances that defense counsel did and that the state attorney during that trial commented on. She said it was a continuance over continuance. And if you look at the disciplinary file of counsel, which was introduced in the record, she was having disciplinary problems with her supervisors at the same time, 11 days before, lack of communication with clients, failing to show up for work. Her assistant didn't know where she were, canceling depositions at the last second. And she moved for trial continuance 3 times. So yes, Your Honor, it is unanticipated, but what was not unanticipated was counsel needed to do something before the middle of the trial, because now her client is sitting there realizing that his main witness is now deceased. And then that evidence through a deposition, which of course wasn't coming in through a perpetration of a deposition because she didn't anticipate that, is thinking, I just heard my counsel say I needed a continuance for 2 to 3 months because I am not ready for trial. And the judge denied that continuance. And that is the position that my client has been put in. And the defense counsel admitted this is her first time in her career she moved for a continuance mid-trial. And I think right then and there, without all the other ineffective assistance of counsel, shows that the voluntariness of Mr. Hayward's plea was not knowingly and voluntarily. And if you get into the other facts, Your Honor, the deposition of Williams gave away some red flags, gave away that the person that was shot, Glenn Brown, who happened to be my client's uncle, they were at a birthday party. And there was a disagreement about cards or something. It was inconsequential. But what happened is after my client realized that Glenn Brown, who, by the way, was established to have a very, very mean reputation for violence. Some people called him a gorilla silverback. Some people called him a bigger than a Jaguar's defensive end, that he snaps, that he's been shot at 20 times, that he carries a gun, that he, hundreds of people, they said, in this Emerson Arms community said that he had a reputation for violence. And then you take it to my client, whose nickname is Fats. And so when the altercation happened, my client realizes that Mr. Glenn Brown's getting upset, and he leaves the situation. He walks away. And what Mr. Williams said is that Glenn Brown jumps off, throws his hat, and goes after and follows my client. So right then and there, what should have happened is the red flag, the light bulb should have went on for defense counsel that there was a reputation issue here. At the evidentiary hearing, it was clear to me, and I think it might be clear to your honors, that she didn't know what reputation for violence in the community was or specific acts. I specifically asked her to define it, and she couldn't. She said she would look it up. There was nothing in her notes that she considered it. And you have to think, why?
Counsel, if I could
Yes,
just jump in here. First of all, I want to make sure that counsel for the appellee is able to hear everything clearly, counsel.
Yes, Your Honor, I am.
Okay, great. So counsel, my question is number one, which witnesses testified at the hearing below concerning the reputation for violence, like not just submitted an affidavit, but actually testified?
Yes, sir. It was Ronald Hayward. And Ronald Hayward is a military veteran and now a senior engineer at Chase Corporation. Ronald Hayward told about specific instances of violence where he had to pull a gun on Mr. Glenn Brown to stop him from violence.
Didn't he backtrack on that?
Sorry?
Am I misremembering? I thought he backtracked on that then on cross-examination and said that he didn't actually pull the gun. Am I misremembering?
I don't want to say you're not. I might be misremembering, Your Honor. All I remember is that there was an altercation at the bar, and then the next day, Glenn Brown wouldn't leave him alone. And I think he went to his car and said he was going to pull a gun. That's my recollection of the facts. But the fact was, this guy, Ronald Hayward, called defense counsel before trial and have a guy talking about a gorilla silverback needed guns to be pulled on him before he stops the violence. And Ron Hayward was a credible witness. Obviously, he is a successful man, served our country. There was no credibility determinations among him, and he testified. And the second one was Morris Tisby, T-I-S-B-Y, Your Honor. And Mr. Tisby reiterated the reputation for violence. These gentlemen are in the same community, and they grew up, and they generations of families is what they said. And Mr. Tisby was punched so hard by Glenn Brown that he woke up in a fireplace after a card game. Kind of a similar situation here with the card game. So we had two.
So I guess then the question becomes, assuming that testimony, that the actual testimony that was offered was enough to establish a reputation for violence, in the trial court then also believed it.
Yeah.
Would that be enough in combination with the very limited testimony that essentially, I don't remember there being any testimony that there was any actual threat, right? I mean, getting up out, sort of the victim got up, with what, threw a hat down or something, and quote, came after your client. Is that enough to pull out a gun and shoot someone without more, sort of more facts there?
Well, you have not only a reputation for violence, but you have the specific instances of violence that my client testified that he recognized those, the ones from Ron Hayward, the ones from Morris Tisby. So now you have two different forms of evidence coming in. You're going to have the jury hear the reputation for violence, which was immense. And by the way, Your Honor, the trial court judge nor the state attorney nor the attorney general discredited the reputation. I think it's coming in. I think we proved it through the numerous people that knew this in the community. But when Mr. Hayward, my client, is walking away, if you take a look at Mr. Williams' deposition and sworn statements, he also indicates that Glenn Brown was about to whip my client. So we're getting to the violence part now. So my client could have testified to that. And we know he was going to go to trial because—
yeah, I saw that. The first thing that comes to my mind with that sort of description is a fist fight. Now, if you think that should be interpreted for something more than a fist fight, you should convince us of that. But is a fist fight is a fist fight in this situation, even with a reputation for violence, is that enough to pull out a gun and shoot somebody?
Again, the size disparity. And I do believe it's more than a fist fight, because my client testified and the reputation witnesses testified that Glenn Brown also is known to carry guns. And he's also a very strong man, 6'2",
But nobody saw a gun.
Nobody saw a gun on Mr. Glenn Brown, correct?
Right.
Yeah. But when you have a man who they say that you have to get to the other side of the street on, that has had numerous beatings of his own friends and knocked people out, I think having a gun to protect that, especially when witnesses have said that's the only way to back him off of you, I think it's very reasonable to consider that if you had a Jacksonville Jaguar defensive end coming at you and you know he's got a reputation for violence, he knows he's beaten up your friends, your uncles and your brothers, and he's intoxicated, he's drunk over a case of beer too. That was in, I think, Williams' deposition or sworn statement, one of the two, that it's very reasonable to consider that. And I think that's what the client wanted to prove. And Your Honor probably saw this as well, that my client did file a motion to withdraw his plea before sentencing. So he was intent on going to trial. The problem was he filed a pro se 30 at 50, and we got the case after all of those. Most of that was, he wrote a pro se 30 at 50.
So I guess, counsel, your client, if I recall correctly, your client took the position that, hey, look, I didn't mean to actually discharge the firearm. Is that correct? Is that the position he took? As Your Honor knows, the case law allows you to do self-defense and accidental. And what I believe the version of that evidence is that he discharged and he didn't think he hit him. And I believe it's even in Mr. Williams, it's either in his sworn or his depo. I conflate the two, and I apologize. That Mr. Hayward didn't believe he shot Mr. Glenn Brown. And so we have an independent witness that unfortunately had passed away, but did provide evidence that that's indeed what happened, is that it was an accidental discharge. And as Your Honor knows, the case law allows that to go forward on a self-defense accidental discharge case under certain situations like this. Well, a couple of questions there. Number one, did the trial court believe that it was accidental? Because it seems like maybe there's a difference between, hey, I was just pulling the gun to get this person to back down versus I intentionally then shot the person, right? Those two things seem very different to me. So, the trial judge is the one that can determine credibility and what facts to believe and what not. So how do you address that?
I don't think it's relevant to this decision, because it still comes down to whether his plea was involuntary, and we have in mid-trial no evidence of reputation being presented, and the client's put in the catch-22. I don't think it's relevant to the knowingly issue, and I take great issue with the trial court's order, and in due respect, I'll say why, because it totally omits the reprimands from defense counsel, which are happening. It totally admits that Ron Hayward and Mr. Tisby were available witnesses. In fact, the order says, well, those guys probably wouldn't have testified because some of the witnesses were difficult to get a hold of, but there's no evidence of that. It just didn't happen. Defense counsel never said it was Ron Tisby or Ron Hayward. She actually thought Ron Hayward was my client's father. So it tells you that there was no investigation done on that. And then the court also says that they were uncooperative witnesses, which is completely contrary to their own testimony and defense counsel. So the order is leaving out facts that I think are highly relevant to this court's analysis. And unfortunately, the answer brief did too.
And I mean, I think that, right, there's two things you have to show, right? The ineffectiveness, and then also, but you also have to show prejudice. And I guess I just wonder if your client's position that, hey, I didn't mean to actually pull the trigger, right?
Yeah.
That might matter on some level if the trial court just didn't believe that, right?
Yeah.
I mean, it's a different scenario. Hey, this person hasn't threatened me. They're coming at me and they're maybe going to fist fight me, and maybe they're bigger than me. But it's a totally different scenario to say, well, I'm going to pull out this gun and very intentionally pull the trigger and shoot this person, right?
Yeah. Yes, sir. And I think the evidence is that it was an accident. I mean, and I'm basing that on an independent witness, Mr. Williams, saying, yeah, he came back and he went over to Mr. Brown. I think what happened was after the shots were fired, Mr. Brown almost made it back to the card table and then he fell over.
How many shots were there?
I think there were multiple, Your Honor. I think one or two hit
I mean,
Mr. Brown.
doesn't that really, I mean, isn't that some evidence that the trial judge could have said, hey, I just don't believe your client when he says it was an accident? Multiple shots?
Yeah, I agree that he could have said that. But again, my client's testimony is not as relevant as the defense attorneys and the witnesses that testified that the defense attorney wouldn't call him back. I think that issue is more for a jury, which my client has always wanted to go in front of and get on the stand and say, hey, this guy charged me. I shot and I didn't know I was going to hit him. I was trying to scare him. I knew that this works before because my friends have told me like this guy does it. I know he can go off as a rocker. He 24 beers since he was sitting at the party. That's a very aggressive individual. And the witnesses that we called, the two, Ron Hayward and Mr. Tisby, as well as Mr. Hayward, said that Mr. Glenn Brown gets more aggressive when he drinks, and 24 beers is an insane amount of alcohol.
Would it hurt your case? Would you have a weaker case? And if so, how? If the trial judge, let's just say for a moment, the trial judge very expressly said, look, you're taking the position here at this hearing that you only intended to brandish the firearm. You didn't intend to pull the trigger.
Yeah.
But I absolutely don't believe it. I multiple shots here. I think you very intentionally pulled the trigger and very intentionally shot the victim.
Yeah.
How much does that weaken your case, if at all, and why?
Does not at all, because it's not relevant to whether he wanted to go to trial. The issue, as Your Honor already pointed out, was twofold. It's ineffective assistance of counsel, which I think is clear from the record and the personnel file of the attorney who was put on probation 2 weeks after this plea.
I mean, don't we look at the strength of your case? Isn't that one thing that a court looks at, the strength of your case, to determine
Yes.
whether your client really actually would have gone to trial?
Yes, but he was in trial.
But hold on. But if your client, if the trial judge says, look, I've looked at the testimony and that you absolutely did this on purpose, sir, you fired the gun on purpose multiple times, doesn't that weaken the case for you?
Under that analysis, I agree. Yeah, I think what Your Honor, and correct me if I'm wrong, I think what you're saying is the totality of the circumstances as to whether the client would have went to trial. That is one factor, absolutely. The trial court did not say that. He said on certain instances he finds Miss Hart, the defense attorney, more credible, but he never pointed out that specific issue. And I don't even think that was raised by my opponent on the answer brief. But if you look at the totality, yes, let's take that into consideration. But the client wanted to go to trial. He was in trial. He filed a motion to withdraw a plea before his sentencing. And he's sitting there in trial just hearing for the first time that either through a deposition or live testimony, his main witness is not coming in, and his attorney's got to pick they're in trial in 47 minutes. And that's
my last question, because I know you're in your rebuttal time here, but
thank you.
When I read the testimony of the deceased witness, I'm going to be honest with you, I didn't think it was very helpful to your client. Yeah. It was somewhat marginally helpful, but it wasn't powerful. It didn't convince me otherwise.
No, I think you're right. But I think, again, that's another reason why the attorney was ineffective. She's banking this whole decision, this whole trial on this guy, and Your Honor's pointing out the obvious, that it would have been a lot stronger if the guy would have charged him and would have said, I'm going to kill you, or some aggravation on top of that. But that's all the more reason for her to go out and find this reputation evidence and return people's phone calls. So I think that's where the issue lies, is let's let this client go to trial, which, his plea was still never accepted, which, I had to raise because the client raised it pro se, but that's all he wants is a trial to prove that, Your Honor.
Okay. You have about 3 minutes and 30 seconds left, counsel, for your rebuttal, and we'll give you a few extra seconds there because it kept rolling, and then we'll have argument from the appellee now. Go ahead, counsel for appellee. You're recognized.
Thank you. Good afternoon. May it please the court, counsel. My name is Christy Reagan, and I represent the state, the appellee in this case. I would like to start by first saying that, quite frankly, this was a very weak case for self-defense and for the claim of accidental shooting. As the court has already acknowledged, the appellant shot the victim on multiple occasions. So the evidence and as well as the testimony of Mr. Williams did not go to any claims of self-defense or that of accidental shooting. As far as the testimony of Mr. Williams, unfortunately, he did pass before the trial. However, his testimony did not enhance the appellant's claim of self-defense. Mr. Williams stated that it was actually the appellant who came over to the table initially on both occasions. It was the appellant who was slamming his liquor bottle on the table, who placed his hands on the table, disturbing the card game that was going on. The appellant wants to argue that he knew of the reputation of the victim, Mr. Brown. However, based upon the testimonies of Mr. Hayward and Mr. Tisby, their testimonies only demonstrated that the victim was involved in fights, not that he had a reputation for violence. So Mr. Williams in his testimony also stated that when Mr. Hayward, the appellant, stepped away from the table, he completely disturbed the game. And that in itself could be considered as an aggressive movement, not so much, the aggressive movement began there and not so much when Mr. Brown stood up from the table. Even with Mr. Brown standing up from the table and he just went in a general direction of the appellant, Mr. Williams stated he did not see Mr. Brown place his hands on the appellant. He didn't the victim at all. And actually the appellant stated that he was startled and surprised. Startled and surprised does not lead to one having imminent fear of death or great bodily harm for which to use deadly force for self-defense.
Counsel, do you agree that the victim, that the evidence showed that the victim was larger than the defendant here?
Based upon the testimonies, it does appear that Mr. Brown was about 6'2", and he was taller and maybe a bit more muscular than the appellant. That is what the testimony describes.
And I mean, in fairness, there was certainly, it seems like there was some testimony here that at least suggests that the victim had a tendencies towards some violent altercations. I'm not sort of putting a label on it for how severe, but there was at least some testimony that one might make that inference. You agree?
Based upon the testimony, it could be inferred as, he did have some tendencies to be involved in fights. However, again, that does not startled and surprised does not rise to the level of imminent fear of death and great bodily harm in which to shoot the victim multiple times. Also, I would like to also address the appellant's argument as far as Ms. Hart being continuously asking for continuances for the trial. It was brought out in testimony that the continuances were due to witnesses not cooperating, not coming to depositions. Sometimes the state filed documents and, there was a report that needed to be gone through before proceeding to trial. So there were times when there were continuances, but it was not just because Ms. Hart didn't want to proceed with the trial, or she was just not putting forth effort and diligence in her work. The appellant has failed to meet the prong of deficiency and prejudice. Based upon the plea that the appellant accepted, he received 30 years compared to, he was looking at life in prison. I'm not sure where the prejudice would have been in that aspect, that he willingly accepted the plea and contending with the disparity of those terms. And as far as Ms. Hart being deficient, just because we all have nicknames. Someone having the nickname of fat is not going to automatically say, oh, well, there is a disparity here. There is going to be a weight difference. There is going to be some type of violence on this person's part based upon a nickname. So I'm not quite sure where the appellant is bringing in the nickname of fat to it having should have caused Ms. Hart to say, okay, well, there is a reputation here that needs to be looked into.
Counsel, it certainly seems like
The-
sorry, I know you can't see us, so are you
I'm
able to hear
I'm
when
sorry.
No, that's okay. It's probably have a little bit of difficulty knowing when we jump in just because you can't see us. So that's why I wanted to make sure you heard me. But I think the point you're making about the nicknames, your point is a persuasive one. But let's go back to the sentence, the exposure, the maximum sentence, and it seems to me that the actual sentence that was rendered is not terribly relevant, but what is relevant is the maximum sentence that the appellant was facing, right? And then compared to in this case, and again, it's possible I'm mixing cases up, but as I recall, the plea here had a cap. Is that correct? 40-year cap?
The state was going to, yes, 35 to 40 years. That is correct.
Yeah. So but your argument, I think, would be if you based it on the cap as opposed to the actual sentence rendered is look, the minimum sentence here what was the minimum sentence, counsel? 25 minimum mandatory?
25, yes, 25 to life.
And the 25 was a minimum mandatory, right?
And that is correct.
Yeah. So the minimum sentence would be 25 years minimum mandatory. That's the best case scenario upon a conviction. Worst case scenario is life. You're saying, look, the plea was a cap at 35 to 40 years. You're saying based on that, appellant hasn't demonstrated that he would have gone to trial. That's essentially what you're saying, correct?
Yes, Your Honor, that is correct.
Do you agree that the cap on the plea is more relevant than the actual sentence rendered? Because at the time he pled, he didn't know what sentence he was going to get, right?
That is correct, but he was under the understanding that the state was not going to ask more than 40.
Right.
So even with a sentence of 40, that is still, again, better than what the state was originally going to ask, which was for life. And I'm sorry, I cannot see you all. Was there another question or?
There's no question pending at this point. Counsel,
Okay.
The floor is yours.
Okay, thank you. I also wanted to address the appellant's claim of self-defense. There was, again, this was a case that was not a very good case for a self-defense claim. I think the attorney was trying to get the appellant to understand the seriousness of the charge. At one point, he wanted to say that it was an accidental shooting, yet the evidence did not support that. None of the witnesses testified to it appearing to have been an accident. And from an accidental shooting, he goes to self-defense. He was in fear because of the victim's reputation. However, the evidence did not support that as well. Ms. Hart tried earnestly to get the appellant to understand that I know you want to claim self-defense. Here is what we're looking at. The defendant himself says that Ms. Hart kept talking to him about what other people were saying and the evidence that was going to be presented. He was not happy with that. And so Ms. Hart, she was basically falling on the sword when she was asking for a continuance, the Ortiz continuance right before the trial. She wanted, and she even stated in the evidentiary hearing, she was trying to get the appellant to understand. There was no other strategy. The best case scenario was for him to enter into a plea, and she wanted to reiterate the importance of what he was looking at of life versus maybe a plea deal. It was the appellant who decided that he wanted to accept
Counsel,
a plea.
why?
So,
Counsel, I'm sorry, I'm going to jump in here real quick again. Why not? I mean, why not be prepared to offer these witnesses who might try to establish a reputation for violence? I mean, why not do that?
I think part of that has to fall back on the appellant. Ms. Hart testified that her, the attorney prior to her, their investigators, they were having a difficult time in getting witnesses to speak. Again, we're talking about the appellant and the victim. They're related. They are cousins. So that's almost family against family. Mr. Hayward even, I guess I should be specific, Mr. Hayward, the appellant, he said that Mr. Tisby and Mr. Ronald Hayward, that they're family. So he had easy access. He just never mentioned these individuals or said, hey, I really need for you to help out my attorney. Please talk to her. So it was not as if these people were completely unavailable to him. They were uncooperative, and Mr. Hayward, the appellant, did not assist Ms. Hart in getting them to come to trial and testify. As a matter of fact, in the appellant's motion for the evidentiary hearing, it stated that he was going to have 4 witnesses. Well, only 2 of the witnesses showed up. So that again shows the difficulty in getting the witnesses to cooperate and to speak on this issue.
Okay, counsel,
And I
don't see-
apologize. I am not.
Go ahead.
I'm sorry. I am not sure what my time is at this moment.
Oh, sorry. Yes, sure. You have 8 minutes left. You can use all 8 minutes or not. It's up to you. There's currently no questions pending though. So you have 7 minutes and 50 seconds.
Okay. Thank you. I guess I will go ahead and sum it up. Again, this was just a case that was not a very good case for a self-defense claim. The attorney tried to get the appellant to understand the seriousness of the charges, try to get him to understand the evidence as was going to be presented at trial. The request for continuances, it was, again, the state acknowledged in the evidentiary hearing that it was because of uncooperativeness of the witnesses, reports being filed. So I think the appellant has failed to show any type of ineffectiveness in reference to Ms. Hart, and he was certainly not prejudiced by him deciding to enter into a plea and getting less than life, which is what the state was going to request. So based upon the arguments of the answer brief and today, we would ask that this court affirm.
Okay, counsel, thank you for your argument there. And then we'll go back to rebuttal. We'll give you 3.5 minutes because I think the clock kept running a little bit, counsel. And whenever you're ready, you can begin your rebuttal.
Thank you, sir. I'll go as quick as I can. My opponent's arguments are not supported by the law or the evidence in this case, and I'll run through that right away. To say that my client has to tell an attorney about reputation for violence and specific acts is absurd because the client's not going to know that. He didn't know that in his pro se motion. That's the attorney's duty. We all know that that's the investigation that needs to happen. And
wait, he didn't know about the reputation for violence?
Well, he doesn't know the law of reputation for violence. I mean, he can't say, hey, I have a reputation for violence. And in fact, he did say, and he testified, and counsel said that, yeah, maybe Mr. Ron Hayward did say this, that Mr. Glenn Brown has problems with attacking people from behind. So there was evidence of that. And the defense attorney couldn't remember whether Mr. Hayward said that, but Mr. Hayward did testify to that at the evidentiary hearing. For my opponent to say that Mr. Glenn Brown's reputation was not severe ignores the testimony of Ron Hayward and Mr. Tisby. 20 incidences where, this is Ron Hayward's testimony, 20 instances where he's been shot at, he's been stabbed at clubs with bikers, he's been jumped on for using racial slurs. He knew Glenn Brown was going to be the one that would be killed because of how he bullies others. He's personally seen Glenn's violence, and he is known to carry a gun. He has a tendency to snap. He's big and muscular. He has 100 people that know about his reputation. He's more aggressive than when he drinks, and he fights people unprovoked, and he's seen him fight and be violent 50 times, quote, easy. And that's just Ron Hayward's testimony. So if that's not severe, I don't know what is. And
why don't you talk a little bit about the cap, the cap on the sentence versus what was right, the minimum and the maximum, and then the cap on the plea.
Sure. Well, first of all, I disagree that the attorney was trying to get Mr. Hayward to understand that he needed to plea because she said she wanted a 2 to 3 month continuance to get prepared and find a new strategy at trial. So that's contradicted by her very testimony during the actual trial and the motion to continue. And when it comes to the cap, I mean, what else is Mr. Hayward going to do? The trial court hypothesized, well, he could have just went to trial, but he just heard his attorney said she wasn't prepared for it. So
well, no, but that goes to whether or not he actually would have gone to trial, right?
Yes, sir. Yes, sir. The cap, I don't hold much weight on the cap. Do I agree that 30 years is a lot different than life? Sure. I mean, I agree with that. But at that point, what other choice does he have than to submit to a plea or go to a trial where an attorney's not prepared? And then he is really looking at life. So I think the cap is not as important as the actual facts that surround the cap and what Mr. Hayward did afterwards. And that's obviously tried to file a motion to say that his attorney didn't provide an adequate representation. And unfortunately, all the attorneys below missed my second issue on appeal under Muse and Spargo, that the trial court never accepted his plea before he filed that motion to suppress or motion to dismiss. Motion to withdraw his plea. And had anyone caught that, even on direct appeal, we wouldn't be sitting here. He would have had his plea automatically withdrawn and went to trial. So, and both the trial court and the Attorney General's office glossed over that. But I would argue under the manifest injustice in the cases I cited in the brief, that's another reason for this court to consider, because filing a motion to withdraw plea is a pretty good indication that you still want to go to trial, and which it would have been granted had one of my constituents caught it. So, Your Honor, those are the arguments. Oh, one last thing, Your Honor. To say that counsel didn't know about this, Mr. Tisby's notes were in the file of prior counsel. So she had information that Mr. Tisby was talking about a prior incident of violence 2 weeks before. So the writing on the wall was there from Mr. Hayward and Mr. Tisby. It wasn't
Thank you,
done.
counsel. Your time has expired. Thank you. Good argument on both sides. And this court is now adjourned. Thank you.
Sir.